Welcome to Glorious IAS Academy. In this session, we are going to discuss about the Article 22. In the previous class, we were discussing about the right to freedom, under which Article 19, Article 20, Article 21, Article 21A and Article 22. In previous classes, we were discussing about the four articles of the right to freedom. This class will cover Article 22. What is Article 22 is talking about protection against the arrest and detention. And there are two types of the arrests are there, punishments are there, punitive punishment and preventive punishment. What do you mean by punitive punishment? It is a punishment after trial and conviction. After trial will be conducted in the court, and if court will be conducted, the punishment will be given. In preventive, there will be no trial, there will be no conviction, and simply you will be put behind the bars in order to prevent you to commit the crime in future. And some sections of the people, they frequently will commit the crimes. So before something going to religious affairs will going to happen, people, some cops will arrest some particular persons. Those who are prominent rowdies in that particular locality, they will be arrested without any punishment, without any conviction, without any investigation. So those arrests will come under the preventive punishments. So what is the difference between the punitive punishment as well as the preventive detention or punitive detention? Under the punitive detention, first crime is committed, then police will conduct the investigation, and in third phase police will gather some evidences in the investigation, and after that they will arrest that particular person, those who committed the crime, and they will produce in the court, and court will give the remand, and after remand they will take out the bail and they will come out. Then trial will be continuously conducted in the court in series of sessions. So after, if they found guilty of that crime, they will punish it by the court of law. So this is the procedure that will be followed in the punitive detention. But no procedure, this procedure will not follow under the preventive detention. Simply the police will get some intelligence information, the subject will be arrested. There will be no investigation, no gathering, no trials. So they will simply detain in the jail, and the purpose of this detention not to punish that person, but to prevent that person from committing the crime, preventing that person from committing the crime. So that is the fundamental difference between the punitive detention and preventive detention. Simply understand, punitive detention is after the trial, conviction, the punishment will be given. Under the preventive detention, without trial and conviction, the person will punish. So next one, there are certain kind of provisions under the Article 22, Article 21 and 22, Article 21 of 1, Article 21 of 2 is talking about the punitive detention. These two articles under the Article 22 will talk about the punitive detention. First, right under this article, right to informed of grounds of arrest. If any person arrested after being committed the crime, they should inform that on what grounds they have arrested that person. Second one, they will have a right to defended by the legal practitioner. So after they arrested, they will allow to hire a lawyer and legal practitioner against the arrest. Third one, they should produce before the magistrate within 24 hours of the arrest. If when any person arrested within 24 hours of arrest, they should produce the magistrate. So if they are not produced in front of the magistrate, they will have a right to release after 24 hours. Unless if the magistrate allows, then they will arrest, the period of arrest will be more than 24 hours. If the magistrate will not allow, they will have the right to release from the jail after 24 hours. So these are the four. One is grounds, another one is legal practitioner, another one is time of the period to be in jail. So these are the four fundamental rights included in under the Article 21 and 21(2) of the punitive detention. So there are certain limitations imposed under this article. First one, these safeguards not available to the enemy allies, those who are foreigners, and under the preventive detention law. And also the person, those who are arrested under the preventive detention law, first group, these rights will not applicable to the enemy allies, means the person belongs to Pakistan. For example, the person belongs to Pakistan will not access to these rights under the fundamental rights. So second one, those who are arrested under the preventive detention law, that these rights will not applicable to those persons. And another next one, the apply only in act of criminal and quasi criminal crimes or some activity prejudicial to the public interest. So those who are in the criminal offences, semi-criminal offences or quasi-criminal offences, these rights would be applicable. And move to the next articles, Article 21 of 4 to 21 of 7, 21 of 4, 22 of 5, 22 of 6, 22 of 7. These four articles will talk about the preventive detention. Under this, if a person detained under the preventive detention law, that they cannot hold more than 3 months. The person cannot be detained more than 3 months. 3 months unless a advisory board would be set up to frame the rules and regulations to arrest the persons under the preventive detention law. The period of the detention in the jail without any trial and conviction would be only 3 months, not exceeding the 3 months. Maximum period is 3 months. If you hold that person more than the 3 months, the advisory board should be reports the extension of the person, extension of that period. And also, if any person arrested under the preventive detention law, the person should be communicated on what grounds you have arrested, so the grounds of detention should be communicated. And third one, the opportunity to make recommendation. You will allow, the victim should allow, those who are arrested, those victims should allow representation against their detention under the detention order. Next one, this right is both available to both citizens as well as the aliens. And no democratic country, this is very, very important, no democratic country other than India will have the preventive detention law. Only preventive detention principles only included in the Indian constitution. Any other democratic country would not have this kind of preventive detention rules. Next one, Article 22, Parliament can prescribe certain things. Number one, it can prescribe these circumstances and class of cases a person can be detained more than 3 months. If a person can be detained more than 3 months under preventive detention law, the Parliament will have the authority in what circumstances, under what class of cases they can hold more than 3 months under preventive detention law without obtaining the opinion of the advisory board. If the police wanted to hold that person more than the 3 months without any opinion of the advisory board, so those cases and those circumstances will be decided by the Parliament of India. Next one, the maximum period for which person can be detained in any class of state under the preventive. So the maximum, whether it's 3 months or 4 months or 5 months, the maximum period will be fixed by the Parliament itself. And also what procedure should be followed by the advisory board. If advisory board will allow the person to stay more than 3 months in the jail, on what conditions and what procedure should be followed by the advisory board. So number one, the procedure should be followed by the advisory board, the maximum period, and more than, if they wanted to stay more than 3 months. So these are all rules and regulations will be framed by the Parliament of India under Article 22. So Article 22 will give certain authority to the Parliament to prescribe certain rules and regulations related to the preventive detention laws. And according to this Article 22, Parliament has come up with the 44th Constitutional Amendment Act 1978. 44th Constitutional Amendment Act, it reduced the period of detention without advisory board 3 to 2 months. So without advisory board, you cannot stay, the police cannot hold any person more than 2 months. The period reduced to 3 months to 2 months. 3 months to 2 months under the 44th Constitutional Amendment Act 1978. So these laws are these rules and regulations framed by the Parliament by using the power under the Article 22 itself. So what are the legislative powers given with regard to the preventive detention? So legislative powers are divided among the Parliament and state legislatures. Parliament as well as the every state legislatures, they will have some powers to legislate upon the preventive detention laws. What are those? Parliament given the powers under the defense, they can pass the preventive detention law and they can enact the laws, some laws related to the foreign affairs and security of states. Only these powers given to the parliament, and when various parliament and state legislatures both will have regard the security of states, maintenance of public order, maintenance of supply and services essential to the community. So in these matters, the parliament and state legislatures both will have the certain kind of powers to legislate or enact the different kind of laws for the preventive detention, means preventive detention laws. So we have discussed in this class what is preventive detention, what is punitive detention. Article 22 mainly talking about the two important things, punitive as well as the preventive detention laws. So what Article 22 is about? It is a protection against the arrest and punishment. And what are the rules and regulations for punishing? What are the rules and regulations for the trialing? These are all are included in the Article 22. So by using the powers in the Article 22, Parliament had come up with certain kind of laws. First law, Preventive Detention Act, it was expired in 1969 itself. Maintenance of Internal Security Act 1971, it was removed in 1978. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. National Security Act 1980. Prevention of Block Marketing and Maintenance of Supplies of Essential Commodities Act. This is very, very important. Previously, in lot of competitive examinations, asked some questions about this act. Terrorist and Disruptive Prevention Act, TADA, in 1984. So like that, the various acts passed by the Parliament as well as the state legislature time to time by using the powers under the Article 22. So in this class, we have discussed about the Article 22 elaborately. What is the meaning of Article 22? What is punitive punishment? What is preventive punishment? What is the difference among them? What are the legislative powers of the state government and central government, Parliament as state legislatures? What are the important acts? What is the preventive detention? What are the grounds of under the preventive detention? What is the maximum period of the preventive detention? That is the 3 months. And unless the advisory board is advising the extension of the periods, they cannot hold more than the 3 months. Thank you very much.